Good morning and welcome, everyone. Welcome to another session of Caffeine Coaching, hosted by CEO Academy. I'm Carl Ranger, Head of Training here at CEO. And today we have something very interesting in store. It's a case law discussion or lessons from case law, where we'll be discussing one of the latest Constitutional Court judgments. You can see the citation on the screen there. It's AFGRI Animal Farms versus NUMSA and others. Has quite a significance in the labor field, which we'll be unpacking today. We are streaming live on LinkedIn, Facebook, and YouTube. So to all our attendees, to those just tuning in, welcome. Thank you for joining us. I'm joined by two of our expert dispute resolution officials here today, Christy and LeMay. Christy, LeMay, welcome.
Thank you. Morning, Carl.
How are you guys doing?
Morning, Carl. How are you? Hi,
Good. Thank you for joining me today.
Carl, but all right.
Glad. Thank you for joining and taking time out of your day. You guys will be taking us through this significant judgment and its impact on employers specifically. So without further ado, before I hand over to you guys, I do just want to say to all our viewers and those tuning in, there's a QR code on the screen over there. It takes you to our CEO Academy website, where you will see our 2024 training schedule and our event schedule. We have some interesting trainings there for the rest of the year. We have a promotion for CEO members, as well as for non-members who want to join. They will then, once joined, how can I say this, be benefited by the promotion. So two of our trainings for August on the 13th and the 23rd will be dealing with handling different types of misconduct specifically. On the 13th, we'll be touching on dishonesty, negligence, and insubordination. And then on the 23rd of August, progressive discipline, as well as absenteeism. Some prevalent offenses that employers handle day to day here in South Africa, and we'll be taking the people or attendees and our delegates through the whole process from start to finish, from the referral on once the workplace offense has been conducted, and then through to the arbitration process, how to conduct the arbitration, how to prepare for it, witness preparations, the whole toot. So please join us there. Please feel free to take a photo on your camera of the QR code. It'll take you to our website there to benefit from the promotion. I will display this slide at the end of the training or the discussion today as well, for those who have missed it. Without further ado, let's get on with today's discussion. All right, so I'm very excited about this. I have a passion for points in limine and litigation specifically within labor. So this judgment means a lot to me, and I'll explain, or Christian LeMay will be taking you guys through it to explain why. As you guys will see, some banners will come across the screen from time to time. If you are tuning in from Facebook, LinkedIn, or YouTube, please feel free. If you have any questions or any comments, please feel free to pop them through. We will address them live as we go. So I would like, for people's engagement, for all our team's engagement, if you have something to say or a question, we would love to hear from you, and we'll handle it as we go. All right. Constitutional Court judgment. Christy, what is the crux of this matter? So I want you to take us through maybe the legal question, explain to our attendees why and what happened in this matter. What do the courts have to ask?
So thank you, Carl. So, surely in this instance, what actually happened, or what the legal question is whether or not NUMSA could represent the employees in the labor court if those employees were not members to NUMSA's, or in accordance with NUMSA's constitution. So normally in labor matters, when a union's constitution would actually come up, it would be an organizational rights dispute. But in this case, it was a dismissal dispute, and AFGRI actually raised the point in limine pertaining to NUMSA's ability or lucus standi to represent these dismissed employees, because it doesn't fall within the scope of their constitution. So basically, the court went deeper into whether or not a union is able to represent employees in a dismissal dispute if their own constitution doesn't allow them to recruit members in that industry in the first place.
100%. No, geez, well said. I think what is so interesting about this for me is that it follows on or builds on from the Leffield packaging case. I think it was in 2019, which was a specific dispute to org rights and also dealt with representation, also NUMSA, funny enough. And, the court then specifically stated that representation for org rights, the members of the union have to be or fall within that scope of that industry. So they had blocked it, but only specific to org rights. It hadn't gone across to unfair dismissal disputes or to other disputes, as the Concord judgment has now, opened the floodgates to, which is great for employers across the board.
Yeah, no, I mean, for sure, Cole, and in this case, the Constitutional Court actually did also touch on that judgment, and I'll also be mentioning something about it later as well, yes.
Awesome. Thank you so much. LeMay, would you like to take us through the background of the dispute, just to, build on the merits and the facts to, for our viewers to hear actually what now happened, what led to this legal question that the courts had to answer?
No, definitely. Thank you, Cole. And I think Christy touched on it as well now when she explained the crux of the matter, but maybe just going a step back and see where it all began will put everything in perspective for our viewers. So the dispute on representation itself in this matter arises when the employer who manufactures and distributes animal feeds, this is a very specific industry, they dismissed some of their employees who participated in an unprotected strike. Now, the unprotected strike followed when the employer refused NUMSA organizational rights. And again, the refusal of the organizational rights is because NUMSA's constitution does not make provision for the animal feeds industry.
Yeah.
So when these employees were dismissed, NUMSA then on their behalf referred a matter, unfair dispute or unfair dismissal dispute to the CCMA. It remained unresolved, and then it went to the Labour Court. But at the Labour Court, the employer then defending themselves again, they raised this point in limine, or this point to say that but NUMSA does not have legal standing or locus standi, as we call it. And they argued that the Constitution, which they are bound by, prohibits the dismissed employees from becoming members with NUMSA. So NUMSA's Constitution specifically reads that persons working in the metal and related industries are eligible for membership. And this was the employer's argument from the onset. How can they be members if they are not in the metal or related industries?
Yeah.
So I think just to put everything more in perspective, when the matter was heard at the Labour Court, and I think I'm not going to repeat each and every paragraph of the Labour Court's judgment, but I just want to refer to the turning point in this matter. And to add on where you mentioned now Lufel, and there's actually another matter, McDonald's Transport, where the court, NUMSA is relying on those two judgments, and they're saying, but they're allowed to represent. But the turning point at the Labour Court was when the court rejected NUMSA's argument, when they said that legal standing because the Constitution is only applicable when it comes to organizational rights and not an individual's unfair dismissal dispute or referral. So the Labour Court ruled that the trade union can only act on behalf of members falling within their scope, which is registered. And that is valid for all inquiries. And that would automatically include an unfair dismissal dispute. Yeah. So the Labour Court further stated that NUMSA's argument and referral in terms of Section 200 of the Labour Relations Act was invalid and void. And I'm not going to dwell to Section 200 just yet because we will deal with it later. NUMSA was not happy with the Labour Appeals judgment and finding, and the Labour Appeal Court actually overturned the Labour Court's ruling, and they went back to Lufel and McDonald Transport, where they said you must distinguish between these two, because these two are different. Organizational rights and an unfair labour dispute must be separated, because organizational rights is the union's right and the individual employee's rights, where an unfair labour dispute or unfair dismissal dispute is between the employee, the individual, and the employer. But this is not where it ended. Yeah. The matter then continued. The Constitutional Court's analysis. Yeah.
Before we get there, I just want to say what is so interesting for me is in 2019 when the Lufel packaging case came out, I interpreting the fact that, yes, I know it only applied to collective bargaining or org rights, and the point in limine that we'd raised that locus standi regarding representation of the trade union, I wondered to myself back then, how does this not apply across the board? And, then the complication comes in with the Bill of Rights and the Constitution of South Africa, where, people have the freedom of association, as well as, fair labor practices to choose your own representative, where members of a trade union would join trade unions outside of their industry, which didn't make sense to me at the time, because surely if you have a scope, you should be bound by that scope, and you should be recruiting, representing, and so forth within that industry. But obviously it's a little more complicated than that. So Christy, I'm going to move on to the next point of discussion here and hand back over to you. But would you mind taking us through the Constitutional Court analysis of how they got to answering these questions and, dealing with the fact that Lamay just alluded to?
Yeah, sure. Cole, so, when the Constitutional Court basically analyzed the facts before them, they looked at two sections. The first section was Section 161 of the Labour Relations Act, and then also Section 200. So I just want to quickly take us through what these two sections says, because maybe our viewers don't know. But so Section 161 talks about the representation before the Labour Court in any Labour Court proceedings. So a person can either appear on their own behalf, or they can be represented by a legal practitioner, a director, or an employee of the party, any members or office bearer or official of the party's registered trade union, a registered employers organization, a designated agent, or an official of the council, or an official of the Department of Labor. But and then Section 200 actually goes to the representation of employees or employers. So here we're zooming in on exactly what the court wants us to, or what to get to, is the representation basically by registered trade unions or employers organizations. So in terms of Section 200, a registered trade union or registered employers organization may act on more of the following capacities in any dispute to which any of its members is a party of its own interest on behalf of the interest of the members, or on behalf of its members. So in this case, the Constitutional Court actually found that they're not going to focus on Section 161 because it does not apply, because the NUMSA employees and NUMSA was represented by a law firm. So the Constitutional Court actually found that in this case, what would be applicable is Section 200, 1, 2, and B. So the unions in this case would be acting on behalf of the members and their own interest. And that's the reason why Section 200 would actually be applicable. Just basically focusing on the fact that NUMSA is not litigating on their own behalf, but on those of their members. So that's why 200 would be applicable and not Section 161, as also mentioned in the Labour Court at that stage. So, moving on also to representation rights, when the Constitutional Court actually considered representation rights of NUMSA, they went back to Section 95 of the Labour Relations Act, which deals with the registration requirements of a trade union. Now, one of the requirements in terms of Section 95 is that the Constitution must prescribe the qualification for the admission of membership. Maybe, basically setting out their scope, about who are they going to recruit, who are they going to represent. So in this current case, NUMSA's constitution didn't make provision for the employees which were in AFCRI's employment. The constitution doesn't go to that scope, so it didn't include the current employees. And what the court also said is that one of the effects of the legal personality of a trade union is that it may only perform acts which are in the constitution and require and permit them to do so.
Yeah.
So for that reason, the Constitutional Court basically said, listen, NUMSA's constitution doesn't go to the extent of these employees, and which makes the representant they were acting outside of their scope and beyond their powers.
Yeah, it was ultra vires. Yeah.
Yes. They couldn't represent the employees.
Yeah.
Yes. So, also what they touched on is the validity of the membership of the unions. Of the employees, for them to actually be part of the union. So the Constitutional Court referred to Section 41B of the Labour Relations Act, because now we're getting to the point where, these employees are still entitled to being represented by a trade union as per, our own constitution and pertaining to the Labour Relations Act. But Section 4 actually emphasizes that every employee has the right to be represented by a trade union subject to their constitution. So, as I mentioned,
subject to, very important.
Yeah, and NUMSA's constitution restricts them from actually recruiting members in the animal feeds farm because they were not entitled to be members due to the constitution of NUMSA. So this is where the court also touched on the importance of what was said in Lufil Packaging versus the CCMA. So yes, as you also mentioned, what happened during that case is that it was basically about organizational rights, where the court said, listen, you would only have lucus standi when it's about to
within collective bargaining.
Yes, in collective bargaining, but yes, in this case, they said it's only when it's covered by your constitution. So the Constitutional Court basically has said that unions are not allowed to represent members outside of their scope, and they're only allowed to recruit members within their scope of their constitution.
Yeah. No, thank you, Christy. Geez, I think what is so interesting, and specifically for employers, is this pretty much invalidates the membership validity for why people join trade unions, is because if they can't be represented or sufficiently represented through the authority of the trade union, there's no locus standi for them. So it's actually changing, or it's going to have a significant effect through South Africa, in the sense that trade unions, their whole membership base will change, because there's a lot of trade unions representing and recruiting members outside of their scope, outside of the industries that their trade union was established for. So definitely, I think when their members start referring disputes and they see that their trade unions cannot represent them, it'll have a significant impact, because these are the arguments that we'll be raising on behalf of our members, on behalf of employers at the CCMA on the ground level. And the wonderful thing about the ConCourt judgment is not a labor court or a labor appeal court, it's constitutional court. So it's the highest court in the land ruling in favor, or in this way. And I mean, that has the precedent that it sets is actually significant on the ground level. Just before we move on to the next point, which I'll handle, I see we have some technical difficulties. LeMay, unfortunately, has a bit of issues there, so not to worry. The show will go on. But from your side, Christy, have you seen anything on the ground level, when you're handling disputes? I know you had mentioned to me previously that you raised this argument in one of your disputes.
Yeah, so I mean, Cole, as we're sitting here today, I'm actually waiting for my point in limine. But yes, getting to the CCMA, actually now dealing into what the implications are of the judgment. But we see trade unions going out of their scope, representing any employee that they basically find or that they heard of, and this would have an impact on them being represented at the CCMA. And I hope that my judgment, my ruling would actually be in our favor, so that it could also be one of the stepping stones for our employers to go into raising the point, especially when unions are recruiting outside of the scope of their constitution.
100%. Actually, the courts are just setting the record straight. What should have been there in the first place. Now the Con Court has ruled in favor. Yeah. But moving on to the judgment there, let me just take us through it. So pretty much all of this led to the appeal being granted and succeed. The Constitutional Court granted the leave to appeal and upheld the appeal. It set aside the Labour Court's decision ultimately, where the Labour Court's decision was set aside. The original ruling of the Labour Court was then reinstated. So really good. What that means for employers is that there was no legal standing for NUMSA in this dispute. NUMSA was found ultimately to have no legal standing to represent the dismissed employees, as they weren't valid members of the trade union, as Christy had rightfully said. So they were acting ultra vires, a Latin term to say they were acting outside of their scope, outside of their authority. And then this leads to the jurisdictional point, or the point in limine, that we ultimately raise on the ground level at the CCMA on behalf of our employers. It's one of the first things we check. And now it's something we can check across the board for any dispute, because as Christy said, this originally only applied to collective bargaining through the fuel packaging case, and specifically org rights. Now, where the trade union is present, we have to check on behalf of our employers and do our due diligence to see whether they can provide their constitution to us on the day. And if they can't, unfortunately, they must get out. There's no locus standi if they cannot prove or shift that onus to say, yes, we have the correct legal standing to be here. Would you agree?
No, I agree, Carl. I was just thinking about the circumstances where, for instance, we are not necessarily involved in any, negotiations internally with the because there's also actually, when I raised my point in limine, this also came up, the employer had been dealing with the union, but now I raised the point in limine, but you actually had no locus standi in the first place to be negotiating with the employer in the first place. So, that would also be rather interesting, which we actually need to make the employers aware about whenever they're dealing with the union in the first place, were they allowed to be there from the onset. Exactly. So not only raising it at the CCMA or bargaining councils or the Labour Court, but also, internally as well.
No, 100%. Hence this discussion that we're having today. But Christy, moving on, could you please tell our viewers, and especially for the employers out there, why this matters for employers? What does it ultimately mean for employers moving forward? If you can just take us through some practical conclusions regarding this judgment.
Well, I think we've mentioned it now basically over and over again, but the judgment basically clarifies that trade unions must only represent employees within the scope of their constitution. So this decision from the Labour Court made it now very clear that unions are not allowed to overstep their bounds of their constitution. So it's not only now more, still in organizational rights, but across the board for all matters. Yes.
In the event, sorry, I just have a question. And I know we know the answer to this, but just for our viewers out there, in the event that, the trade union's locus standi or authority to represent is questioned on the day and they can't provide their constitution, for employers out there who may be unrepresented, the commissioner at the CCMA or maybe the chairperson internally, they will have to state that for the record to say, well, listen, sorry, you can't provide your constitution. You're unable to represent this applicant or this employee here today unless you can prove that you have the legal standing to be there. In that circumstance, it does not mean the end of the matter. The applicant, it's still their case or the employee's case, and the matter will still proceed for that applicant or for that employee, but without their representation. Most likely, they will be afforded an opportunity to find an alternative representative within a reasonable time. So, they at least have that option to ensure that there's still a fair labor practice moving forward. But there will be definitely no representation from outside trade unions where they are not within that current industry in question. Yeah. Is there anything else that you'd like to add there regarding the implications or anything, Christy? I know, sorry, we've now going over our time, but, just to wrap things up.
No, Cole, that's basically it. I think, as you mentioned now, they would be allowed opportunity to find, another representative, which I thought, the implications more could also be at the CCMA and the bargaining council's formal postponement should this arise, because, this applicant is coming to, for instance, to the CCMA or the bargaining council thinking, okay, I'm represented, but now, we as employers organizations come, or HR or IR managers come and they raise this point in limine, and now the applicant actually has to find a union within their scope. So that could also be an implication of what the Constitutional Court has ruled.
Yeah, 100%. Christina, thank you so much for that. For the employers out there, tip of the day: ask for the union scope. Check if they can represent within your specific industry. If so, then no problem at all. If not, raise that point and stick by it. So challenge the membership criteria of the union to see whether they are entitled to represent. It might just change the outcome of the dispute as well as how it proceeds. I see we have just a thank you over there. Thank you so much for tuning in, everyone. If there are any questions, sorry, our viewership has been a bit quiet today. We actually encourage the engagement across the board. So if you do have any questions, please feel free to pop them through to us. Comment on this video on social media, whether it's on Facebook or LinkedIn, and we'll get back to you with the answer to your question, or just to give you feedback on your comment. Christy, from my side, thank you so much for taking your time out of your day. To LeMay, who we lost along the way, unfortunately, thank you for joining us as well. We hope the employers and for all the attendees, legal representatives, trade unions alike, I hope you guys found this informative. And just from my side, thank you so much for attending. As I said in the beginning of the presentation, please feel free to scan the QR code there. We do have a great promotion coming up for August. This is our TO Academy 2024 training schedule and event schedule. You'll be able to see the events right up until the end of the year. Please feel free to inquire with us as well. And we hope to see you at the next one, guys. Thank you so much for your time. Thanks, Christy.
Thank you, Carl.